Hello everyone, this is Aparna Bhat. Welcome to Unacademy Judiciary YouTube channel. Today's topic for discussion is solving the 2019 Kerala question paper. Okay, so we have already solved two question papers, that is one is with respect to 2022 question paper, that was the recent question paper of Kerala Judiciary or Kerala Municipal Magistrate examination. Then yesterday we solved a 2020 question paper. Today we would be solving 2019 question paper, and tomorrow, as a part of the continuation of the entire Kerala previous year question paper series, Kerala previous year question paper analysis, tomorrow we will be solving 2017, then 2016, so likewise. Okay, so totally there are about 100 questions. I would be discussing them with small explanation within a span of about 1.5 hour or 1 hour 45 minutes. So please do answer in the chat box where you can answer the right multiple choice question, right option in the multiple choice question. So without any delay we can start this. And also one more important thing, see here there is a new announcement. You can see that there is a offer again which is going to extend till 28th, from February 22nd till February 28th we are having this offer, and the important key characteristics are that you can save up to 20% and up to free 6 months you are having this. Okay, so just give me a minute so that I can check whether the streaming is proper with the proper audio and other this one. Just give me 2 minutes. Yes, now it is streaming properly. I hope the audio is also clear. Okay, everyone is audible. My voice is audible, I guess. There's a new offer which is that is extra 6 months you will be getting. So again I will be repeating this in the end of the class, but please note that there is free All India scholarship test is there on March 5th and different batches are there. So all these details I will be giving in the last, and these are our YouTube channels. I'll explain with every aspect in the end of this class, but without any delay we can start with the today's class, that is about Kerala Judicial Service preliminary examination of 2019. Okay, is everyone ready? Can I start? Hello Vinny, good evening. So as we all know, Kerala question paper is for duration of 2.5 hours and for 200 marks, which consist of 100 objective multiple choice questions with 1 mark negative marking for every wrong answer. There are 3 parts, part A, part B and part C. Part A consists of civil law, part B consists of criminal law, and part C is with respect to constitution. Hello Simona, good evening. Yes. Okay, so let's begin. See, in this question paper, very few questions have been deleted, and the answers are a bit confusing. Only for a very few questions, not for all questions. I'll mention which question is that, but rest of the answers have been provided as per the final key answers, which is uploaded in the High Court of Kerala recruitment website. You all can refer that as well, because entire set of Kerala, all question papers along with final key answers are uploaded on the website. So it's a very good option. Okay, so which of the following statements relating to the definition of decree in section 2.2 CPC is untrue? A. Decree means a formal expression of an adjudication conclusively determining the rights of the parties. B. It shall be deemed to include the rejection of the plea. C. It shall be deemed to include the determination of any question within section 47 CPC. D. It shall be deemed to include the determination of any question within section 144 of CPC. Yes. So you all have answered as C. Yes, of course it is C, because see section 47, earlier it used to be, it was considered to be a deemed decree, but not now. That provision has been deleted. Okay, only rejection of the plaint and order under section 144 are considered to be deemed decrees. Next, second question, which provision deals with the situation in which a court can direct to take off the plaint? This is a very new kind of remedy, where the defendant is asking for taking off the plaint of the file. Take off the plaint. Should I zoom it? Wait. Okay. So taking off the file with cost to be paid by the pleader to the defendant. So the provisions are Order 9, Rule 9, Order 32, Rule 2, or Section 35A CPC, and Order 7, Rule 11 of CPC. Okay. I hope this is clear. The questions are visible. Mir. Yes, what is the answer here? It is the question under B. It's not the rejection of the plaint, but it is something where a suit is instituted without the next friend. Suit instituted without next friend. In that case, we will be having this option under Order 32, Rule 2. Next one, third one. Which of the following is not a condition for removal of next friend of a minor? Which is a not condition? Because minor's name suit will be filed by the next friend, that next friend will be removed. To remove this next friend, if he is something of a different nature, he will be removed because it would be adverse to the interest of the minor. So which among them is not a condition? In this question paper, you can see most of the questions are negative questions. So please pay attention while answering. A, where the next friend is found to be not a relative of the minor plaintiff. B, where the interest of the next friend is adverse to that of the minor. C, where the next friend is so connected with the defendant whose interest is adverse to that of the minor. And D, where the next friend ceases to reside within India. What's the answer here? It is so this is not a relevant condition. A. Yes, Mir is answering. Mir, Winnie, yeah, I can see. Also Simona. Here A is the correct answer under Order 32, Rule 9, okay, which speaks regarding removal of the next friend. The entire rule is with reference to that. All others are the conditions. If these conditions are there, then that next friend can be removed. Fourth question. Which of the following is not a condition for withdrawal of permission to sue as an indigent person? A, if the indigent person is guilty of vexatious or improper conduct in the course of the suit. B, if it appears that his means are such that he ought not to continue to sue as an indigent person. C, if he has entered into any agreement with reference to the subject matter of the suit under which any other person has obtained an interest. D, if he refuses to take the help of a pleader assigned by the court. So what's the answer here? It is not a condition for withdrawal of permission. This is a provision under Order 33. It is not a condition. Again a negative question. Order 33. Yes, it is D. If he refuses to take the help of a pleader assigned by the court. Under Order 33, Rule 9, which speaks regarding the withdrawal of the permission. Fifth question. All questions between the parties to a suit in which the decree was passed or the representatives and relating to the something dash shall be determined by the court executing the decree. A, execution of the decree. B, satisfaction of the decree. C, discharge of the decree. And D, execution, discharge and satisfaction of the decree. Because court executing the decree is something where it cannot refer some questions back to the original court where it has to again refer to different questions. Rather than that, the court executing the decree, it itself can decide certain questions. So what are such questions? If any questions are relating to the execution itself, or whether regarding the discharge of the decree, or with respect to the satisfaction of the decree. Yes, it is a question under section 47. Executing court cannot go behind the decree. This is also a very famous saying. D is the correct answer for fifth one. Sixth one, which of the following is not a reason for issuing an order of arrest before judgment under order 38 rule 1 of CPC, which is not a reason. Issuing an order for arrest before judgment. A. The defendant has absconded or left the local limits of jurisdiction of the court. B. The defendant is about to abscond or leave the local limits of jurisdiction of the court. C. When the defendant has committed waste in the plain scheduled property. D. When the defendant has disposed of or removed from the local limits of jurisdiction of the court his property. What's the answer here? For arresting before judgment, it is, if it is shown that the defendant, he himself is going to leave the property, leave the jurisdiction, or with respect to property, he is disposing that property. If he shows any of these conditions, then arrest before judgment can be ordered, but this is not a condition. When the defendant has committed waste in the plain scheduled property, this is not the condition. Others are the condition under order 38 rule 1, attachment arrest before judgment. Next comes the seventh question, where an injunction has been granted without giving notice to the opposite party. The court shall make an endeavour to finally dispose of the application within dash days from the date on which an injunction was granted. A. 30, B. 60, C. 45 and D. 90. What is the answer for seventh question? Within how many days an injunction order, injunction application has to be disposed from the date on which injunction was granted. If interim injunction was granted, then the finality of this order, when should it be disposed? Yes, it is within 7 days from the, within 30 days from the date on which the injunction was granted. Next question, eighth question. Which among the following is not a requirement under order 21 rule 66 CPC in a proclamation for sale? Okay, this is a question about proclamation for sale. So you have to issue a proclamation. In that proclamation, certain details have to be there as per order 66, order 21 rule 66, which is not a requirement. A. Details of the title documents including number, year and name of the SRO. B. The revenue assessed upon the estate to be sold. C. Any encumbrance to which the property is liable. D. Amount for the recovery of which the sale is ordered. Eighth question, what is the answer? It is, see, if a property is there, its encumbrance, its title, but not title documents, which property, that has to be referred. Amount for the recovery of which sale is ordered. So all those things have to be referred. It has to be mentioned, but this is not an essential requirement. A. Okay. So all these title documents, details of them, including number, this is not at all required. Ninth question, general rule regarding production of original documents under order 13 rule 1 CPC, if they are not produced along with pleadings, is that A. The parties or the pleaders shall produce them on or before adducing evidence in the case. B. The parties or the pleaders shall produce them on or before the settlement of issues. C. The parties or the pleaders shall produce them at the time of final hearing. And D. The parties or the pleaders shall produce them before reserving the case for judgment. See the question properly. So, when are you supposed to produce the documents? As per order 7, order 8, you have to produce the documents like copies or original along with the plain or written statement. But if originals are not produced, then you have to submit them, you have to produce them before the settlement of issues as per order 13 rule 1. This is the correct answer. The parties or the pleader shall produce them on or before the settlement of issues. 10th question. Death of a plaintiff or defendant shall not cause the suit to abate. A. If the plaintiff or defendant has a legal representative. B. If the suit is won to vindicate a public right. C. If the right to sue survives. D. If the plaintiff or the defendant had assigned the property pending suit. Yes, Mir, correct, exactly. Order 7, I guess. What you are saying? Order 7 and order 8. So, when does the suit does not abate, even if the death of a plaintiff or the death of a defendant occurs? Options are: if the plaintiff or defendant has a legal representative, if the suit is won to vindicate a public right, C. if the right to sue survives, and D. if the plaintiff or the defendant had assigned the property pending suit. So, what is the correct answer? It is C. if the right to sue survives. Next one, 11th question. What are the prerequisites for abandoning a suit instituted by a minor plaintiff under order 23 rule 1 of CPC? What are the prerequisites? A. It can be abandoned with or without the leave of the court. B. A simple application for leave of the court is enough. C. An application for leave shall be accompanied by an affidavit of the next friend stating the reasons for abandonment. D. An application for leave shall be accompanied by an affidavit of the next friend and also by a certificate of the pleader to the effect that abandon proposed is, in his opinion, for the benefit of the minor. Okay. So, this is a question regarding the abandonment. So, a suit is filed by a next friend on in the name of a minor, right? And such is the case. If he wants to abandon the suit of a minor plaintiff, then what all things are required? Of course, court's application for leave, court has to give permission. Along with that, affidavit to the next friend and also certificate by a pleader saying that whatever abandonment he is doing, it is for the benefit of the minor. So, all these three things are required, hence D is the correct answer. 12th question. Okay, then these are all regarding our rent provisions, local law. Okay, so just I am going to say the answer, I am not going to explain because every local law varies with respect to their states. So, which of the following person is not a tenant within definition of section 2 subsection 6 of Kerala Buildings Lease and Rent Control Act of 1965? A. Person by whom rent is payable for a building. B. A person on whose account rent is payable for a building. C. A person placed in occupation of a building by its tenant. D. Heirs of a deceased tenant. This is a question under Kerala Buildings Lease and Rent Control. Hence, the correct answer is C. A person placed in occupation of a building by its tenant. 12th question. 13th question. Choose the wrong option. See the entire question paper, we can see these type of questions only, like which is not a condition, which is not a requirement. Choose the wrong option, choose the incorrect answer. So nothing contained in section 11 of the Kerala Buildings Lease and Rent Control Act 1965 shall apply to a tenant whose landlord is A. the state government, B. the public authorities notified under the act, C. the central government, D. a trust coming under the purview of the Indian Trust Acts of 1882. So what is the correct answer for this? It is D. It is section 11. So it comes under proviso to section 11. Yes, Aarti, you are answering 12th B. Yes. And the 13th question is D. There are about 4 or 5 questions are there with respect to this act. Then 14th question, the principle of constructive res judicata in section 11 CPC are applicable to the proceedings under Kerala Buildings Lease and Rent Control Act 1965. This statement is A. true. Should I zoom it? Okay. B. partly true insofar as section 11 subsection 3 of the act is concerned. C. false. D. partly true to the extent of section 11(8) of the act is concerned. It is false. Constructive res judicata is not applicable to proceedings under Kerala Buildings Lease and Rent Control Act. Next 15th question. On the death of an original tenant under the Kerala Buildings Lease and Rent Control Act, his legal heirs succeeded to the tenancy as. How do they succeed? A. joint tenants, B. tenants in common, C. co-tenants, and D. co-owners. The basic difference between joint tenants and tenants in common is how after the death of one of the tenants means one of the owner. Here tenants means not this tenant. This tenancy is different. In this tenant it refers to the estate as the owners. This is the principle of the English law. So there one is by survivorship, another is by succession. On that basis joint tenants and tenants in common is classified. But what about here? The legal heirs succeeded to the tenancy as joint tenants. A is the correct answer. 16th. Which of the following powers of rent control court does not possess? So generally most of the rent control court do not have this power. So it is A. discovery and inspection, B. enforcing the attendance of witnesses, C. reception of evidence taken on affidavit, D. issue an order of temporary injunction. It is so as per section 23, rent control court cannot issue an order of temporary injunction. 23 of Kerala Buildings Lease and Rent Control Act according to that provision. Okay, next question, 17th question. What is the remedy of a respondent against whom execution of an order of eviction under Kerala Buildings has been ordered by a municip's court? A. respondent can file an appeal. B. respondent can file a revision to the court to which the appeals ordinarily lie against the decision of the municip. C. the respondent can file a writ petition before the High Court. D. the respondent can file an application under section 47 CPC before the executing court himself. So what is the answer here? This is a question under section 14 of Kerala Building Lease and Rent Control Act. Here it is B. The respondent can file a revision to the court which the appeals ordinarily lies against the decisions of the municip. And the last question of Rent Control Act. See, what are the provisions in the Kerala Buildings Lease and Rent Control Act requiring a notice before initiation of an eviction proceedings? A. Section 11 and Section 11.3, Section 11.2 and Section 11.8, Section 11.2 and Section 11.4.1, D. Section 11.4.1 and Section 11.8. It is which requires a notice. So this is a purely a memory based question. In these type of questions, like if you are very exact, you are very certain about the provisions, only then you have to answer, because you have a negative marking. Yes, it is C, Aarti, correct. Okay. Section, yes, notice. So we have completed about the questions relating to the Rent Act, then Contract Act. When one person signifies to another his willingness to do or abstain from doing anything with a view to obtain the assent of that other to such act or abstinence, he is said to make proposal, promise, an offer and a consent. A very simple, direct question from Indian Contract Act, a very basic question. Yes. So what exactly is it known as per Indian Contract Act? It is a proposal, right? In Indian Contract Act it is known as proposal as per section, it's the first definition, section 2A of the Indian Contract Act. Next, 20th, an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the others, is a void contract, voidable contract, unilateral contract, and D, rescinded contract. Yes, it is voidable contract. There is a difference between void agreement and void contract as well. So please be very careful while answering this, whether if suppose answer would be this, void contract. So you have to check whether the answer was required for agreement or void contract, because void agreement means they are void ab initio. Void contract is something where it ceased to be valid. It was valid for a particular period of time, it had all the requirements of the contract, but later it ceased. But for this is a different option, it is a voidable contract. 21st question, which is the wrong answer? Consent is said to be free. Consent is said to be free when it is not caused by A, coercion, B, undue influence, C, fraud, D, misunderstanding. There are different causes for consent. Consent is said to be not free. So how is it caused? How is it not caused? For coercion, you say consent is not there, undue influence also, fraud also, but misunderstanding is something different. If it would have been mistake, then even it would have caused no consent. But this is a different thing, misunderstanding. If it was misrepresentation, even then it would have met this criteria, but not this. 22nd question. Yes. A and B jointly owe rupees 1 lakh to C. 1 lakh to C. Now A alone is paying 1 lakh rupees, and B is also knowing, without knowing, he is also paying 1 lakh rupees. So it amounted to 2 lakh, but originally they both were owing only 1 lakh rupees. So is C bound to repay the amount? If so, to whom? Whether this person, is he bound to repay the amount? C. Is he bound to return that extra 1 lakh rupees? Which one? Which section? Mir? It is it is section 72, right? So as per this, what is the correct answer? It is C. Under section 72, which is payment done under mistake or coercion, that will be coming under this. This is the illustration given under section 72 only. 23rd. A contracts to repair B's house in a particular manner and receives payment in advance. A repairs the house but not according to the contract. What is B's right? A. B is entitled to recover from A the cost of making the repairs conform to the contract. B is not entitled to recover any amount as A has effected repairs to the house. C. B is entitled to recover the entire money paid to A in advance with interest as he made a breach of the contract. And D. B is entitled to recover the entire money from A without any interest. Hello, law study, good evening. Okay, you are from Varanasi, very nice. Nice to know. Yes, what is the answer here? 23rd. Even this is the question, this is an illustration based on section 73. If we refer to illustration F, so B is right. According to B is right, A is the correct answer. B is entitled to recover from A the cost of making the repairs conform to the contract. Okay. So when there is a breach of contract, they can ask for the damages. 24th question. A contracts with B to pay 1000 rupees if he fails to pay B rupees 500 on a given date. A fails to pay B rupees 500 on that day. What is the remedy of B? A. B is entitled to recover 500 rupees only from A. B is entitled to recover any amount as compensation from A. C. B is entitled to recover from A such compensation not exceeding rupees 1000 as the court considers reasonable. And D. B is entitled to recover from A rupees 500 with reasonable rate of interest. The question is based on section 74, where it speaks regarding penalty stipulated, where penalty is stipulated with respect to that. Okay. So here C is the correct answer. 24th, C. B is entitled to recover from A such compensation not exceeding rupees 1000 as the court considers reasonable. 25th question. Okay, please read this. In a suit for specific performance of agreement for sale of immobile property, when does the plaintiff acquire title to the property? Because first an agreement to sell is there, then in specific performance they are asking there that please grant this execution of this document as per this. So when do they get the title to the property? A. The sale consideration is paid. B. The suit is filed. C. The sale deed is executed. And D. The decree is passed. It is when it is C. The sale deed is executed. Next 26th question, pick up the wrong answer. When the defendant invades or threatens to invade the plaintiff's right or enjoyment of property, the court may grant a perpetual injunction in the following cases, namely A, where the defendant is a trustee of the property for the plaintiff, B, where the invasion is such that compensation in money would not afford adequate relief, C, when the defendant, who is a co-owner, attempts to trespass into the co-ownership property, D, when the injunction is necessary to prevent multiplicity of judicial proceedings. Again, pick up the wrong answer. So, section 38 says, or specific relief act, when a court can grant a perpetual injunction. So, under various provisions, okay, this is a case 38 subsection 3, this is clause A, this is where defendant is trustee, clause A, where invasion is such that a compensation money would not afford adequate relief, it is clause C. Then this is D, only this is not there. When a co-owner, when he tries to attempt to enter into the property, against that injunction can't be granted. That's why C is the wrong answer, thereby this becomes a correct answer for this question. 26 C. Next 27 question, state whether true or false. A minor may draw, endorse, deliver and negotiate a promissory note, bill of exchange and check so as to bind all parties except himself. Because the contract or whatever, the parties have to be competent. But what about the case, in the case of a minor? Whether it is true, B, false, C, partly true, a minor can only draw such a negotiable instrument and it binds all parties including himself. D, partly true, a minor may negotiate such instruments binding all parties including himself. So, what happens? It is a true statement. Okay. Next one, 28th question, where a check is crossed generally, the banker on whom it is drawn shall not pay it otherwise than to A, banker, B, a banker to whom it is crossed, C, an agent of the banker and D, the drawee. When a check is crossed generally, so the banker, so it is payable through only through the account, bank account. Okay, that's why under section 126 general crossing, special crossing, so many things are there. 126 of Negotiable Instrument Act deals with general crossing. Next one, 29th question. Under section 3 of the Transfer of Property Act, what do you mean by an instrument? Instrument means A, a non-testamentary instrument, B, a testamentary instrument, C, a sale deed and D, a gift deed. Instrument. What do you mean by non-testamentary instrument? The answer is A. 29, answer is A. It is something which is not related to will, other than that. Non-testamentary. We have testamentary and non-testamentary instruments. This is something other than that. Thirtieth question. A contracts to sell a property to B. While a contract is still in force, he sells the property to C, who has notice of the contract. Can B enforce the contract against anyone? What is the extent of its enforceability? A, B cannot enforce the contract against A. B can enforce the contract only against A, but to the full extent. Yes, Mir, correct. Then C, B may enforce the contract against C only to a limited extent, and D, B may enforce the contract against C to the same extent as against A. This is a question based on Transfer of Property Act, where it is with reference to obligation annexed to ownership. Obligation annexed to ownership. So what is the right answer? It is D. This is a question under section 40 of Transfer of Property Act. So B may enforce the contract against C to the same extent as against A. Okay. Next, 31st question. Which of the following is a wrong statement? So many statements, 4 statements they have given. These are the statements are related to the rights and liabilities, that rights and duties of. Is this enough zooming? Wait, one by one I'll it's not compatible. See the first one. The seller is bound to disclose to the buyer any material defect in the property or in Abhi, is it visible now? Screen. The seller is bound to disclose to the buyer any material defect in the property or in the seller's title thereto, of which the seller is and the buyer is not aware, and which the buyer could not with ordinary care discover. This is the first option. Next option B. The settler is bound to produce to the buyer on his request for examination all documents of title relating to the property which are in the seller's possession or power. Next C. The seller is bound to answer to his best of information all relevant questions put by the buyer. And D. The seller is bound to hand over possession of the property in all cases at the time of executing the contract for sale. Okay, so these are the 4 options. So what is the wrong statement here? All these are either rights or duties under section 55 of Transfer of Property Act in the case of a sale of seller and buyer. It is D. D is the wrong answer, because not at all cases, only when whole consideration, whole purchase money is paid, only then. Okay, so 31st D is the correct answer. Then 32nd question. A forfeiture of lease under section 111G of TP Act 1882 may be waived by acceptance of rent which has become due since the forfeiture, B. distress for such rent, C. an act on the part of the lessor showing an intention to treat the lease as subsisting, and D. all of the above. Section 112 of Transfer of Property Act deals regarding the waiver of the forfeiture. So as per that, all these are one of the grounds where it can be waived. That's why all of the above. D is the correct answer. Next, so what will happen? 33rd question. What is the effect of a material alteration of a negotiable instrument? Okay, so these are the options. First option, it is voidable as against anyone who is a party thereto at the time of making such alteration. One option. Then B, it is void as against anyone who is party thereto at the time of making such alteration and does not consent thereto. Second option. Then third one, it is void against all persons, and D, it is voidable against all persons. What is the correct answer here? 33rd question. It is B. What is the relevant provision? Section 87 of Negotiable Instrument Act. Next question, 34th. Choose the most appropriate answer. So, no suit under section 6 of the Specific Relief Act 1963 shall be brought against. Whether there is a bar on the suit against central government, state government or any government or the statutory corporations. It is, yes, it is the government, any government as per section 6 of the Specific Relief Act. Yes, Meer and Aarti. Yes. Then 35th. A without authority buys goods from B. Afterwards, B sells them to C on his own account. B's conduct implies. Now, what does this imply? A ratification of the purchase made for him by A. B a consent given to A to make the purchase. C an agreement authorizing A to purchase the goods for B. And D an unauthorized act on the part of A. Yes, it is a ratification. It amounts to ratification of the purchase made for him by A as per section 197 of Indian Contract Act. There is an illustration according to that. The same illustration has been provided. Next, 36th question. Every transfer of immobile property made with an intent to defeat or delay the creditors of the transferor shall be dash at the option of any creditor so defeated or delayed. A void, B non-est, C voidable and D invalid. So, what happens here? It is voidable. Fraudulent transfer, section 53 of Transfer of Property Act. Thirty-seventh question. A relief claimed in the plaint was not expressly granted by the decree. The relief is deemed to have been A impliedly granted, B granted, C refused and D did not arise for consideration. So, where do we find this? This is the principle of res judicata. Under section 11, they say that if a relief has been asked and that a relief has not been granted, then that amounts to deemed refusal. That is why C refused. Under explanation 5, exactly, refused under section 11, explanation 5. 38th question. Right to appeal. What is the right to appeal? Right to appeal is a statutory right, inherent right, C natural right and D fundamental right. Then what is the right to file a suit? Right to file a suit is an inherent right. Anyone can file a suit. But can you go for an appeal as a natural right or an inherent right? Or only if the statute provides, would you be filing a appeal? Right to appeal is a statutory right. Only if statute gives, only if CPC says that for these appeals, for these decrees it is appealable, or CRPC says for these judgment this is appealable, only then you can go for an appeal. It is not inherent right, it is a statutory right. Okay. You can also find the reference in Darshan Singh versus Rampal Singh. Rampal Singh. Okay. With respect to suit, okay, fine. 39th question. Then section 62 of Indian Contract Act 1872 deals with A. Contract of indemnity, B. novation, C. joint liability, and D. contract of guarantee. What is the answer here? Section 62. Even I think some yesterday's question paper we had seen this. They had asked differently, like what is a novation. So it is nothing but A, B, novation. Section 62 deals with the novation. And last question in part A. An application was filed by the plaintiff to withdraw a suit with permission to file a fresh suit on the same cause of action. The munsif refused permission and dismissed the suit. The order is legal, improper, proper and illegal. Order 23, Rule 1, Sub Rule 3. As per this is the, you can withdraw the suit with liberty to file a fresh suit. That's what it says. If some formal defect is there, or if it suffices certain sufficient cause. When that is the case, yeah, even I find it as improper, but key answers have been given as illegal. Okay, this has been given as illegal. Even according to me, it could be improper, but they have given it as illegal. Maybe because the judge he is not supposed to refuse permission, because it is, this provision itself is with liberty to file fresh suit. Maybe because of that. There is a very thin line between improper and illegal. Okay, so 40th question we have completed so far. Then let's go to part B regarding criminal law. A magistrate dismisses a complaint after inquiry holding that the identity of the accused is not disclosed in the complaint. The order is A. correct, since it is mandatory to describe the identity of the accused in the complaint. B. correct, even if the identity is disclosed in the inquiry, as it is not revealed from the complaint. C. incorrect, since it is not mandatory to describe the identity of the accused in the complaint. And D. incorrect, since the proper course for the magistrate was to reject the complaint. If the identity is not disclosed in the complaint, so what is the option? See what they have done here? The magistrate has dismissed, so whether this action is proper or not. Yes, so identity, yeah, so dismissal is not proper because it's not mandatory to describe the identity of the accused in the complaint. C is the correct answer. Next one, 42nd question. A person went to a police station and, is it visible? Gave a statement that he killed his wife. Okay. Then on the basis of that statement, a crime for offence punishable under section 302 IPC was registered. That statement is admissible in evidence as a confession, since he gave before registration of the crime. Admissible in evidence as an admission of the accused regarding death of his wife. See, not admissible in evidence since barred under section 25 of the Evidence Act. And D. not admissible in view of bar under section 162 CRPC. What's the answer here? It is okay, but it is they have provided key answer as B, which is admissible in evidence, because it amounts to admission of the accused regarding death of his wife. B they have given as the right answer. Confession is not admissible. This they are stating it as admission. Admission could be something regarding death of his wife. Okay. So 43rd question. A complaint alleging offence punishable under section 500 IPC was sent by the magistrate under section 156(3) CRPC for investigation. That order is irregular, since police can investigate only if a complaint is filed directly before police. B. Incorrect, since magistrate cannot take cognizance of an offence under section 500 IPC on the basis of a final report filed by the police. C. Correct, since magistrate has every power to order investigation with respect to any offence. D. Correct, because only if a magistrate orders, police get jurisdiction to investigate into an offence under section 500 IPC. What is the correct answer here? 43rd question. This is incorrect, because magistrate cannot take cognizance of an offence under section 500 IPC on the basis of final report filed by the police. Next question, 44th question. Which among the following statements is incorrect? Magistrate may discharge the accused after considering the police report and documents thereto. B. Considering the police report and documents thereto and hearing the accused. C. Considering the police report and documents thereto and documents produced by the accused. And D. Considering the police report and documents thereto and examining the accused. Which one for the last question? 500 IPC relates to this one, no, defamation. Sessions court can take cognizance in that. It's not the magistrate. Clear? Then 44th question. So that's only where sessions court can take cognizance, and also under this one where committal is done. Then which among the following statements is incorrect? A magistrate may discharge the accused after considering the police report and documents thereto. B. Considering the police report and documents thereto and hearing the accused. C. Considering the police report and documents thereto and documents produced by the accused. D. Considering the police report and documents thereto and examining the accused. In this, what I feel is, as per section 239, according to me, this is the correct answer, like after examining. But key answers they are provided as this. C. Documents, rather than this, it is 173, report under 173 if it was to be accepted. But as per section 239, where it speaks regarding the discharge, it is regarding the examining the accused. But answer has been given as this. So I don't know the reason, like why they have given as this. For me, if I would be there, I would have answered this, D. 45th question. In a warrant case instituted but it asks what is wrong. Okay, correct. Then this one, yes, examining, hearing and all that, all. Then C. Even I got confused. I was thinking that this exactly it fulfills this. So documents and also along documents 173 like that. So they have taken part. Yes, then it is C is correct. Got, Aarti? Next, 45th. In a warrant case instituted otherwise than a police report, the complainant and all the witnesses cited were examined and all the documents were considered before issuing summons to the accused. On appearance of the accused, which among the following shall be proper procedure? A. Magistrate may decide to discharge or frame charge on the basis of the statements and documents aforesaid. B. Magistrate may decide to convict or acquit the accused on the basis of statements and documents aforesaid mentioned. C. Statements of the witnesses recorded under section 202 CRPC after their cross examination can be used as evidence at the trial. And D. Magistrate shall record evidence on the side of the prosecution before deciding to discharge or frame charge. So, we can see the question if you want once. 45th question. This is a case under case which speaks regarding evidence for prosecution. Evidence. Hence D is the correct answer. It is section 244 CRPC. These are lengthy questions. I cannot fit in this window. If I zoom it, you may not be able to view the entire question. See here. The magistrate convicts an accused and sentences him to undergo imprisonment for a term of 1 month for stealing an article. So, this is a theft worth 1000 rupees under section 379 IPC. The judgment will be correct if what? If the conviction is on the basis of plea of guilty, the accused is below the age of 18 years. See, the trial is a summary trial, and D, the accused is a woman. So, what kind of trial if it would be proper if this stealing 1 month imprisonment and 1000 rupees fine is given. If it is a summary trial as per section 260, summary trial. Then 47 question. Okay, so how to give this? So, during trial of a case, the accused was found to be a person of unsound mind. Magistrate on enquiry found that the accused was incapable of making his defence. Magistrate on examining the materials on record discharged the accused, finding that no prima facie case was made out. The decision of the magistrate is A. Correct, B. Wrong, C. Wrong, since the magistrate could do so only after recording a finding that the accused became capable of making his defence, and D. Correct only if it is done after recording evidence on the side of the prosecution. For the 7th question. So, what about the decision of the magistrate when he is discharging the accused of a person of unsound mind? This is a case under section 329. So, when no prima facie case is made out, then he can be discharged. It is correct, A. Subsection 2 says it so. It can be discharged. So, no like these conditions directly you can, that is possible. 48th question. While a munsif was hearing a case, the plaintiff in that case quarrelled with the defendant inside the court, causing interruption to the proceedings. The munsif may take cognizance of the offence and after hearing the offender, sentence him to pay fine. B. May forward the case to the magistrate having jurisdiction to try the offender. C. May on his discretion discharge the accused if he tenders an apology. And D. All the above are correct. This is a case with reference to the contempt provisions. If this is a question, this is a case under section 345 where contempt is there. If not under this, then he can go for 346. He can forward to magistrate under section 346, or if he tenders apology as per 348. Hence all the above are correct. 345, 346 and 348. Next one, 49 question. Okay, so a person committed theft at different places in Ernakulam on this date and this date in the same year, in 1 year, 1 calendar year. He may be charged together with one composite charge and tried at one trial. B. He shall be charged for each offence and tried separately on each such charge. And he may be charged separately for each offence and tried at one trial. D. None of the above is correct. Yes, it is. He may be charged separately for each offence but tried together, because all these are occurring in the same year where section 219 of CRPC is applicable. Section 219 CRPC. One composite charge, no. Separate charges but trial bundled. One trial. A distinct charge should be there always. Separate charge. 50th question. Which among the following statement is incorrect? Any number of persons accused of the same offence committed in the course of same transaction can be tried together. Then, different persons accused of offences of theft of an article, receiving of it and concealing of it can be tried together. Then, all persons accused of different offences committed in the course of the same transaction can be tried together. So, different offence, same transaction, theft, same this one. And the last one, all persons accused of criminal misappropriation committed by them jointly during a period of 24 months can be tried together. So, what is the fate of this question? It is D, because not 24 months, it is only within 1 year, 12 months. All these are the provisions of section 223. Next one, see this. Prosecution wants to admit a report issued by Assistant Director of the State Forensic Science Laboratory in evidence without examining its author. Just a report. The accused objects it. The report can be admitted in evidence without examining its author as a witness in court. B. Can be admitted in evidence only if its author is examined as a witness in court. C. Cannot be admitted in evidence even if its author is examined. And D. Cannot be admitted unless Director of the State Forensic Science Laboratory is examined as a witness in court. What happens here? This is the report of a scientific expert. That's why section 293 explains that even this person, different authorities it has given, among them State Forensic Science Laboratory is also there. That's why can be admitted in evidence without examining its author as a witness in court. Next, 52nd question. A person was tried and convicted for offences punishable under section 279 and 338. Later, the injured dies as a result of this injury sustained in the incident. So, earlier it was a hurt case, now it is a death case. Can the accused be tried for offence punishable under section 304A IPC? Because double jeopardy question comes. So, but when the consequences are different, when there are different consequences, can the accused, he cannot be tried since it amounts to double jeopardy. He can be tried and it does not amount to double jeopardy. C can be tried only if the state government consents, and D can be tried only if the accused was acquitted in the first trial. So, here he can be tried as per section 300 of CRPC. He can be tried and it does not amount to double jeopardy. Next, 53rd question. During investigation of a case involving offence punishable under section 302 IPC, who is competent to tender pardon to an accused? A. Sessions Judge, B. Subdivisional Magistrate, C. Judicial First Class Magistrate, and D. Chief Judicial Magistrate. Who can give tender of pardon to the accused under section 306? It is D. Chief Judicial Magistrate. Okay, 53, Chief Judicial Magistrate, CJM, he can tender pardon. 54th. During examination in chief, a prosecution witness stated that it was he and not the accused who committed the offence under trial. There is one statement by the prosecution witness. What shall then the magistrate do? A. He shall implead that witness and try him together with the accused. B. Proceed with the trial of the accused and decide it. C. Stop the proceedings. And D. Initiate a separate case against the witness and try him separately for that offence. So, what is the answer here? Fifty-fourth. So, it can proceed. So, there is no difference. Okay, and the court can decide even if the prosecution witness has said that. He has the court is having power, but the court can proceed with the trial of the accused and decide it. Next one. 55th question. 54. You are saying A, section 319. Okay. Okay, let me check this. Because the key answers was given as this B. Let me check again. Tomorrow I will let you know regarding this. Right now I don't have the Bare Act. Let me check the actual provision. 55th. A magistrate convicted an accused which among the following is legally incorrect. A. Sentences him to undergo imprisonment and to pay fine. B. Sentences him to undergo imprisonment and to pay compensation. C. Sentences him to undergo imprisonment and to pay fine and compensation. And D. Sentences him to undergo imprisonment and to pay fine and to pay a part of fine as compensation. Is it visible? Legally incorrect. It is B. This is incorrect. To pay fine and compensation, both. Either fine and to pay a part of a fine as compensation. This is true, but this is wrong. Both fine and compensation. Okay. Next, 56th, a complaint alleging an offence exclusively triable by a court of session is filed before a magistrate. As to the procedure on such complaint, which of the following statement is incorrect? A. Orders investigation under section 156(3) CRPC. B. Orders investigation under section 202 CRPC. C. Decides to hold enquiry by the magistrate himself. And D. After examination on oath of the complainant, calls upon him to produce all his witnesses. Which is incorrect? If it is exclusively triable by a court of session, it is section D, section 202, as per this proviso. As per this was supposed to be the correct answer, but key answer they have given this B. So some doubts are there, that too in 2022. So too many discrepancies were there. So even I doubt some questions, maybe the options, or maybe I don't know if different this is there, or what they say, different set A, set B, like that. So let's have certain doubts with respect to some question, but let's see. Okay, as because it is a final key answer, we cannot completely disregard them, because only after all objections, considering the all objections, some reasons could be there. Maybe some other superficially this may seem to be a correct answer or incorrect answer. Okay. Next, 57 question. A person accused of an offence punishable under section 302 IPC has been in a judicial custody. Identify the correct statement. A. The magistrate has discretion to grant bail at any time during the period of judicial custody. B. The magistrate shall grant bail if final report is not filed within 90 days of the judicial custody. C. The magistrate shall grant bail if final report is not filed within 60 days of judicial custody. And D. High Court alone has jurisdiction to grant bail to the accused. Section 302, then 90 days is applicable. That's why under section 167 CRPC, B is the correct answer. It's the correct statement here. 58th question. In a case instituted otherwise than on a police report, charge is not framed. On a date of its hearing, the complainant is absent. The magistrate may then discharge the accused if A. The offence is lawfully compoundable or non-cognizable. B. The offence is bailable. C. The offence is lawfully compoundable and non-cognizable. And D. The offence is bailable and lawfully compoundable. So this is, he may discharge the accused as per section 249 CRPC if the offence is compoundable, lawfully compoundable or non-cognizable. 58A. Compoundable or non-cognizable. Got it? See the options together. Under section 249, proviso to clause 2, you can find this. 59th question. Identify the incorrect statement. Period of limitation for taking cognizance of the offence is. What is the period of limitation? Is 6 months, 1 year, 2 years and 3 years. So depending upon the term of imprisonment. 59th question. Limitation we can find it under section 468 CRPC. It is 2 years is not given, right? Hence C. This is the incorrect statement. Next one, 60th question. Complainant is a minister in the state cabinet. Offence alleged is under section 500 IPC. Sessions court is trying the offence. The court shall follow the procedure for. This is special case, okay? Under section 199, Sessions court can take cognizance, but the procedure which is going to follow is that of a, whether it's summary trial, summons case, sessions trial or trial of warrant case. It is D, trial of warrant case. All the sessions court would take cognizance. It would follow the trial of the warrant case. Next, 61st question. A and B together decided to kill X in persons thereof. B along with C committed murder of X on the above facts. Which among the following statement is correct? Together they decided. A committed an offence punishable under section 302 read with 34, punishable under section 302 read with 149. A did not commit any offence. A committed an offence of conspiracy punishable under section 120 B IPC. Where is that question? So what is the punishment for A? So when they together decided, it will amount to criminal conspiracy. D. Criminal conspiracy punishable under section 120B IPC. 62nd question. One of the following is not a punishment provided under the Indian Penal Code. Identify. Imprisonment for life, forfeiture of property, to pay compensation and to pay fine. IPC section 53 is given as the punishment. That's why compensation is not a way of punishment given under IPC. Maybe it could be something in CRPC they might have given, but not under IPC. 63rd question. A person accused of an offence claims benefit of section 84 IPC of the following. What shall not be a consideration for deciding that question? A. The person was of unsound mind at the time of doing the act. B. By reason of unsound mind he was incapable of knowing the nature of the act he was doing. C. By reason of unsoundness of mind he was incapable of knowing that the act he was doing is either wrong or contrary to law. And D. The person is of unsound mind at the time of trial. 63rd question. For claiming benefit of section 84, it is not a consideration if whether later he becomes unsound or not. That could be a different case. At the time of the trial, CRPC provisions are applicable, but not at the time of the committing or doing the act. 64th. A abates B to kill X. In consequence thereof, B stabs X. X recovers from the wound. If B is guilty of attempt to commit murder, to what offence is A liable? A. Attempt to commit murder. B. Attempt to commit abatement to commit murder. C. Abatement to commit attempt to commit murder. And D. None of the above. Sixty-fourth is B. Abatement to commit murder. Under section 108, there is an illustration there. Okay, for explanation 2, you have the illustration. So please refer that. B. Abatement to commit murder. 65th question. An offence under section 294 IPC will be constituted if a person utters obscene words to the annoyance of others in a public place and to the annoyance of others. D. In a public place ignoring objection by others. What's the correct answer? It is C. In a public place to the annoyance of the others. 65C. Next, 66. At trial, it is proved that the accused voluntarily inflicted the victim an injury using a knife. No evidence is adduced to prove that the weapon used is a dangerous weapon. For what offence can the accused be convicted? A. Section 323 IPC, B. Section 324 IPC, C. Section 325 IPC and D. Section 326 IPC. It is section 324, where it says voluntarily causing hurt by dangerous weapons, because it's a knife which is used for cutting, stabbing. So many definitions they have given as per B. Section 324 IPC. 67th question. One of the following is not a necessary ingredient of offence of robbery. Two or more persons conjointly had committed the offence. In committing extortion, the person is put in fear. Commission of either theft or extortion. D. In carrying away the stolen property, voluntarily caused hurt, which is not an essential ingredient. It is A. As per section 390. It is not necessary. Two or more persons conjointly. This is not necessary. As per 390 IPC. Next, 68th question. A person is entrusted with a property and he dishonestly converts that property for his own use. The offence thereby constituted is A. Extortion, B. Criminal breach of trust, C. Criminal misappropriation and D. Cheating. What kind of offence is this? When a particular property is entrusted to someone, then we can say that it is attracted under section 405 IPC. It is for a criminal breach of trust. B. Sixty-ninth question. A person sneaks into a house for stealing. The offence thereby he committed is A. Lurking house trespass, B. House trespass, C. House breaking, D. Criminal trespass. What is 69? It is section 443 of IPC. That is A. Lurking house trespass. When he sneaks into house for stealing. Aarti, okay. Yes, both of you have answered. C. That is house breaking. Sneaking is something like stealthily going. That is lurking. Lurking house trespass, they say. 70th question. Which among the following is a necessary part of forgery under section 463 IPC but unnecessary part of making a false document under section 464 IPC? A. Makes a document, B. Dishonest intention, C. Intention of causing it to believe that the document was made by authority of a person but in fact not under the authority of that person, and D. Intention to cause damage or injury to a person or public. What is this? See, this is an ingredient of section 463. This is an ingredient of 463, dishonest intention. Even this is an ingredient of 463. But this is not. But this is an ingredient of section 464. So that's why, which is a necessary part of forgery under 463. Sorry, ulta I said. 464, ulta. Wait. This is 464, 464, 464 and this is 463. That's why this is unnecessary part for 464. D. D is the correct answer here, 70D. Seventy-first question. At the trial of offence punishable under section 324, which among the following is not a fact in issue? A. Accused caused hurt to the injured. B. Accused and the injured were in inimical terms. C. Hurt was caused not on grave and sudden provocation. And D. A dangerous weapon was used to cause hurt. So when a just offence, it's punishable in section 324, it is due to hurt, grave and sudden provocation and also dangerous weapon, but not whether they are in inimical terms. That is not a fact in issue. B is the correct answer. Who is that? Lord Status. I am doing good. I am doing good. Good evening. How are you? Next, 72nd question. The prosecution has proved that based on a statement of the accused, the weapon of offence was recovered. One of the following facts need not necessarily be proved for the recovery relevant under section 27 of the Evidence Act. Identify. A. The accused was in police custody. B. The police officer shall depose the statement of the accused in court. C. At least one independent witness shall state in court about the recovery. And D. Information contained in the statement of the accused led to discovery of the fact. Which need not necessarily be proved. For proving section 27, then it is C. At least one independent witness. So this is not a necessary one here. 73rd question. A confession recorded by whom is barred under section 25 of the Evidence Act? A. An officer in charge of a police station. B. A customs officer. C. A forest officer. And D. A drug inspector. It is A. An officer in charge of the police station under section 25. Next on 74th, a birth certificate is relevant under section 35 of the Indian Evidence Act because, why is it relevant? Because it is made by a public servant, it is a part of a register regularly kept in the ordinary course of business. C. A public servant. And D. Made by a public servant in performance of his duty under a special law. So 74th question, why is it relevant under section 35? Because it is made by a public servant in performance of his duty under a special law. D is the correct answer. 75th question. C. Signature of the principal of a college is to be proved. He is not available. A teacher worked along with him deposed in court identifying his signature. So one who is acquainted with the handwriting of that person, he came and deposed. So whether such opinion of the teacher is relevant or not. If it is relevant, under which section? Section 45, section 46, section 47 and 73. Here they are asking about the opinion of the person. That's why it is relevant under section 47. C is the correct answer. Yes. 76th question. A gift deed is produced in court. Its execution can be proved even if one of the attesting witnesses is not called. if or provided it is registered and its execution is denied. C, it is registered and its execution is admitted. And D, it is not registered but its execution is admitted. So it is C, it is registered and its execution is admitted. Next one, 77th question. If an agreement is produced in court and proved, which among the following oral evidence cannot be permitted? A, to prove that the agreement is vitiated by fraud. B, to prove that one of the terms in the agreement was incorrect. C, to prove that there was a separate oral agreement between the parties. And D, to prove a custom which has a bearing on the terms of the agreement. Oral evidence cannot be permitted. To prove what? So under section 91, this question is, it is B, to prove that one of the terms in the agreement was incorrect. Next, 78th question. A suit for partition is filed by the heirs of a person whose whereabouts are not known for more than 7 years. Yes. So in this suit, if the plaintiff proves that nothing has been heard about the person by those who would naturally have heard of him if he had been alive, the burden to prove that he is alive is shifted to the defendants. B, if the defendant proves that nothing has been heard about the person by those who would naturally have heard of him if he had been alive, the burden to prove that he is alive is shifted to the plaintiff. C, if the defendant prove that the person was alive within 30 years, the burden to prove his whereabouts have not been known for the last 7 years is shifted to the plaintiff. And D, none of the above. 78th. So in this question it is A, regarding section 108, burden of proof, who is not known for more than 7 years. Okay. 79th question. A child of 11 years of age is competent to testify in a court of law since the child is, whether he can testify or not. A, above the age of 10 years. B, competent as per section 118 of the Indian Evidence Act. C, competent as per section 4 of the Oaths Act. D, found competent by the investigating officer. So he is competent witness, child also, provided he can understand the questions and answers. So B is the correct answer. Next, last question of this particular this one. So if a former statement of a witness is proved to be inconsistent with his statement as per section 145 of the Evidence Act, A, his evidence shall be excluded from consideration. B, he becomes an accomplice. C, he ceases to be a witness. And D, his credit may be impeached. What can be done if it is former statement is inconsistent? 80th, his credit may be impeached. D is the correct answer. Yes. Next, so we have completed 80 questions. Then only small part C regarding constitution and other general mental ability maxims. So quickly we can complete this. So what do you mean by ipso jure? Ipso jure means A, the law of the land. B, law is supreme. C, by the law itself. And D, in the absence of law. Ipso jure. It is C, by the law itself, or you can call it also as the by the operation of the law, by the operation of law. Next, 82nd question. Rigor mortis. Rigor mortis means a putrefaction of body B. Color change of dead body. C. Skeletonization of dead body. And D. Stiffening of muscles after death. Rigor mortis. It's one of the key factor in the case of post-mortem. So based upon this, they will determine the time of the death, like how much the muscles have become stiffened. Depending upon that, this much time has elapsed after death. So likewise they calculate. That is known as rigor mortis. A person who loves mankind, a lover of mankind, is known as philatelist, philanthropist, see prophet, and the anthropologist. A lover of mankind. It is philanthropist. B. 83. Philanthropist. 84th question. Make up your mind. It means to make a decision, to express a desire, to make an admission, and D. to think about an issue. It is A. To make a decision. Make up your mind means to make a decision. 85th question. Actus curiae neminem gravabit means A. The practice of the court is the law of the court. B. A court has nothing to do with which is not before it. C. An act of the court shall prejudice no one. And D. Where there is a wrong, there is a remedy. 85th question. It is C. An act of the court shall prejudice no one, which is based on, like yesterday we got section 144 and some question was there regarding restitution. Yesterday we got this question, yesterday or day before yesterday, somewhere I had discussed this. 86th question. A judge of a high court is appointed under dash of the Constitution of India. A. Article 279, B. Article 217, C. Article 170 and D. Article 234. A judge of a high court is appointed under which article? It is Article 217 B. B is the correct answer. Next one, 87th question. When can an ad hoc judge be appointed in the Supreme Court of India? A. Whenever the Chief Justice of India deems it appropriate. B. Whenever the President of India deems it appropriate. C. If post of a judge remains vacant for more than 3 years. And D. If a quorum of the judges of the Supreme Court is not available to hold any sitting of the court. It is D. If a quorum of the judges of the Supreme Court is not available to hold any sitting of the court. 88th question. Right to education of all children between 6 and 14 years of age has become a fundamental right as per Article dash of the Constitution of India. A. Article 21A, B. Article 20A, C. Article 23A and D. Article 25A. This has become a fundamental right by virtue of which article? It is, yes, A. Article 21A. Yes, yes, you are also mentioning about the Amendment Act. Good. Next, 89th. Power to issue writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari could be exercised by any court other than Supreme Court of India and High Courts if A. The Supreme Court of India empowers, B. The President of India empowers, C. The Parliament by law empowers and D. None of the above. It is if the Parliament by India empowers, Parliament by law empowers, even other courts also will be having the power. The parliament has to do the law regarding that. Next, 90th question. Ex officio chairman of the Council of States is A. the Speaker, B. the Minister of Parliamentary Affairs, C. the Prime Minister, and D. the Vice President of India. It is D. the Vice President of India. Then, the High Court under Article 227 of the Constitution of India shall have superintendence over dash throughout the territories in relation to which it exercises jurisdiction. A. District courts, B. all courts, C. all courts and tribunals, and D. all tribunals. Supervisory jurisdiction. It is C. all courts and tribunals. Okay, so this was during 2019. So, who has not functioned as Attorney General of India? By that time, it was Tushar Mehta. Okay, so I am not going to explain this in detail because the positions could have changed. He was the Solicitor General of India then. Next, 93rd question. The Chief Election Commissioner of India cannot be removed except by which process? A. resignation, B. presidential order, C. impeachment, and D. judicial decision. Chief Election Commissioner. It is by way of impeachment. Yes. 124. Removal of Supreme Court judge. Likewise 324. 94th question. The obligation under Article 22 of the Constitution of India to produce every person arrested before the nearest magistrate within a period of 24 hours is not applicable in the case of persons A. arrested under preventive detention laws, B. arrested under Narcotic Drugs and Psychotropic Substances Act, C. arrested under Foreigners Act, and D. arrested for the office of sedition. Article 22, this is based on the other what we say, the laws based on the preventive detention laws. These are not based on Article 22. It is not applicable in the case of A. Yes. Next question. So, only 5 more questions are there. In which decision of the Supreme Court of India it approved the principle of prospective overruling? A. Keshwananda Bharati versus State of Kerala, B. Minerva Mills versus Union of India, C. Golaknath versus State of Punjab, and D. Indira Gandhi versus Raj Narayan. Principle of prospective overruling. This is in Golaknath versus State of Punjab. These are some of the mental ability questions. 4 questions are there. So, laugh is to weep. What price is to? If laugh is to weep, pride is to, like the opposite. If you laugh, you have to weep. If you do pride, then you may be subject to humility, insult. Okay, pride means like a confidence, pride. 97th, find out the odd one. Tall, short, laugh, cry, big, huge, D. enormous, tiny. All these are opposites. This is the same meaning, big, huge. Synonyms. These are antonyms. And this question, this is, I think it is, this got deleted. This question got deleted, and maybe even if you try also, some data is lacking. Some more data is needed for this. That's why they might have deleted. So, I am not discussing this. Let's directly go to 99th question. Okay, find out the conclusion which will logically follow from the given statement. Yes, I hope this is visible to you. The statement is, the laws framed by the government for the purpose of giving equal treatment to every citizen on implementation will perpetuate corrupt working system. This is the statement, and two conclusions are there. The law should be framed but they should not be implemented to avoid corrupt working system, and the second conclusion is there should be obvious method to investigate corrupt working system. Okay, so the answers, the options are conclusion 1 follows, conclusion 2 follows, either 1 or 2 follows, and D, neither 1 or nor 2 follows. So according to this, neither one of D is the correct answer. Neither 1 nor 2 follows. And the last question, today's last question is this one. If all players play to their full potential, the team will win the match. The team has won the match. So conclusions are, all players play to their full potential. Second option, some players did not play to their full potential. These are the two conclusions. Now you have to find out which is the statement which follows from this statement. Only conclusion 1 follows, B only conclusion 2 follows, either 1 or 2 follows, or D, neither 1 or nor 2 follows. So it is A, only 1, conclusion 1 follows. Okay. Yes, so ultimately we are done with this 2019 question paper, which was quite lengthy, I guess. It took more time than yesterday. It is about for like almost 2 hours we are solving this, because the questions were very lengthy. Many questions, maybe from the part B, CRPC, Indian Evidence Act and Indian Penal Code, and even many illustrations were given, right? Yes, so thank you. So thank you so much, Meer, Yasra and Aarti Lakshmi. So tomorrow again we will meet at the same timing at 9 o'clock, where I will be solving 2017 question paper. So there is no 2018, directly we will go to 2017 question paper. Thank you so much for joining, and as usual, let me just update regarding some of our new updates and new subscriptions, new offers. So see here, there is a free All India Judiciary Scholarship Test which is going to be conducted on March 5th at 12 p.m. So you are having a chance to win 100% scholarship as well. That's a very important feature. You can enroll into this by scanning this QR code, and see how much ever you attempt mock tests, how much ever you solve previous year question papers, that would be helpful to you. So with regard to this, even I am conducting different multiple choice questions on Unacademy platform, which is a kind of a free special class. Anyone can join, anyone with the link, or who has downloaded the app, they can join. So tomorrow 10 o'clock I will be having multiple choice questions session on CPC, that is multiple choice questions from order 30 to order 40, all regarding minor suit, then pauper suit, with respect to that. So that is one thing. And the offer, you can see that this month if you want to purchase any subscription, there is an offer which is going on. So you can save up to 20%. So up to free 6 months extensions also you will be getting. So 12 months if you purchase, that's the amount would be 50,511 rupees. If you use my code Aparna Law, APARNALAW, you can see that the scroll is being displayed. You can use that. Then that is one thing. And also for Target Judiciary 2024, you can purchase 18 months subscription. Again you will be getting 6 months free subscription, which is worth about 30 to 45,000. So likewise you can save up to 20%, like more than that. So here the offer price is 61,991. And we can see that different batches are there. See, revision batch for Uttar Pradesh mains examination is there. This is for a duration of 3 months, and the total price would be 22,959 rupees for a duration of 3 months. And you have linking batch for Rajasthan Judicial Service and Gujarat Judicial Service. This is also for a duration of 6 months. The price is 36,736 rupees. This is going to commence on February 18th, just like which has already commenced. Then we have Safalta 4.0 comprehensive batch. This is for a duration of 12 months. Price is 50,511 rupees. You can use my code Aparna Law for joining this batch. Then we had Chhattisgarh Judiciary Prelims mock test series are there, which is available only at a very offer price of rupees 500, and this would be having 5 mock tests, 5 full length mock tests are there along with law 2, then criminal law, on English and on Punjabi paper. There will be analysis session by top educators for each test. 3 full length tests for mains exams and model answers are given. Then mains test series for Uttar Pradesh. So how we have for Punjab Judiciary, likewise we have for Uttar Pradesh Judiciary 2023. The offer is valid for only first 100 subscribers, where the price is only for rupees 2,999 only. So the test schedule, you can see it is going to commence from 5th March and it may be extending till 21st March. 3 mock tests will be having. So each mock test will be having, it is like exact pattern of Uttar Pradesh Judiciary, where along with mains examination tests will be there with model answers also. So each mock test will be having general knowledge, then English, Hindi, law paper 1, law paper 2 and law paper 3. So analysis session by top educators for each test will be given. And you can see that most of you are having a chance to win up to 2,500 rupees for every referral of 5,000 rupees. So that's a very good chance. So why don't you refer your friends and win different exciting rewards. This is a very key option which you are having. And you can also join our different YouTube channels. One is Judiciary Prep with Unacademy, then Judiciary World is there, Unacademy Judiciary is there, and Unacademy Judiciary PCS Telegram channel is there. On all these platforms, we will be having different classes. So even my classes, I am actually taking classes for Karnataka Judiciary in Kannada. So even Karnataka students can join my classes. Even in Unacademy platform, YouTube platform also, I have conducted many Kannada classes as well with respect to All India Bar Examination and many such classes, different cases. Okay, so do enroll into these channels where all educators, most of the educators are conducting classes, live sessions which is relevant to your different state specific laws. So this is what I wanted to say, and tomorrow also I'll be there at the same timing at 9 p.m. solving 2017 question paper of Kerala Municipal Magistrate Examinations. So do join the session so that you can answer, you can chat you can give the answers in the chat section. So thank you all of you. Do not forget to like, comment, share and subscribe to this YouTube channel. So see you tomorrow. Let's crack it.